time to get here.
If you're able, rise, pledge of allegiance. To the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, good evening, everyone. If you do not know me, my name is Garrett Olson. I'm an attorney with the Vos Law Firm. We represent the city as its city attorney, and I will be the attorney with you for this year on the Board of Adjustment. I know we have some new members, and the first item of business we have to get to this evening is the election of a chair and vice chair for the board. Or are we approving minutes first on the agenda?
Yeah, I think, well, we should do roll call.
Let's do that first.
Okay. John Kabord.
Here.
Okay, Ronald Berger.
Here.
John Hayes.
Here.
Michael Goldberg. Rick Anderson.
Here.
Summer Powell. He's on the,
Yep, I'm here.
all right. And James Cole. He is excused.
Yeah.
Okay, then election. The
The
next order.
approval of minutes, but from August meeting.
Well, we could do the approval of minutes first if you'd rather.
I mean, I never saw them, so I don't know.
You never saw them?
Were they weren't in here.
I believe it was the storage containers.
Oh,
They
yeah.
moved it to
Now
a
I
different-
remember it.
Remember it?
Yep. Yep. Goldberg second motion. Okay.
Yep.
Our agenda.
I haven't had a chance to review those either. Do you want to take a moment to pass those around and then we can accept the minutes?
Yeah, we'll do it later then.
Our agenda contemplates that we're going to elect a chair and vice chair first, and then we'll do that process. And
Okay,
then we'll
that's
get
fine.
to that.
Now, an election is legal even if you have two board members who haven't been technically even sworn in?
Yeah, so again, this is just a procedural item for the board, right? There are no action items on the board, so we're not worried about, impacting anyone's entitlements here. This is just the board's way of governing itself, right? Having someone in charge, someone step in case that person's not able to go for that particular item. So what I'd recommend is that we move forward, elect a chair, a vice chair, and if there are any subsequent issues that come up, which I do not believe there would be any, we can always, restart the process at a later meeting date. So with that, as I spoke to you all before the meeting, the way that this usually goes down is that I'll call for nominations for chair. Once there's a nomination made, I will wait for a second. At that point, I will ask the nominee if they accept the nomination. And if they affirm that they do, I will call for a voice vote. All in favor say aye, all opposed like sign. And at that point, if we have a chair, I will pass the duties of electing a vice chair on to the chair. So at this time, would anyone like to make a nomination for chair?
Who wants to be the chair?
And you all can discuss it beforehand as well.
I'll nominate Don. He was the vice chair, so it's kind of last year, so.
All right, I have a nomination. Is there a second?
I second.
All right, we have a second. Do you accept the nomination?
Yes.
Awesome. All right, all in favor, signify by saying aye.
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 All opposed, like sign. All right, congratulations, we have a chair.
For the 18th time.
Do you actually know what number it is?
No, I have no idea. No idea.
I'd be interested.
It'd be in the 90s I started, so.
All right, cool.
Okay.
So go ahead and
Thing
let's,
is, I'd like to see if anybody would like to make a recommendation for a vice chair. Thank you. You know,
Huh?
I'd like,
Vice Chair?
Yeah, I'll take it.
yeah, I'll second it.
so is there a nomination?
Yeah, Ron.
Accepts the nomination?
We could call
Yes.
it someone who's been on here at least 1 year.
Yep,
Yeah.
See, next year, and plus, we're only gonna serve what?
couple of months.
Oh, just to the end of the.
9 months? And then, do you have any cases coming up that you know of
We have one at least, maybe two,
next month?
probably, yeah, next month.
All right, let's call the vote on that nomination.
You call the vote.
Yeah, I'm just trying to think. We got the first, the second, and all in favor?
Aye.
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 Okay, there
Aye.
All right.
All right,
5-0.
cool.
So that passes 5-0. We have a new vice chair, Ron. Congratulations.
Thank you. Congratulations to you. Welcome the new people.
And we'll discuss the minutes in a minute. We have no conflict, we have no interest, and you can do your presentation.
Sure, if we're going to approve the minutes later on, I think
Want-
that would be appropriate.
Ron's reading them.
Yeah, this is fine. It's what we agreed to.
I'll pass it down there and then.
Well,
even necessary.
I watched it on YouTube. I wasn't present for the meeting, so I would have no reason to object to it.
There you go. Okay, so do we have an approval of the minutes of the August of 23 meeting? All in favor?
Aye.
Aye. What's the date?
August of
August.
23.
Wow, that was the
August
last one.
16.
Wow.
Months ago, yeah.
Yeah.
Okay, I guess now we turn it over to you, sir,
Did
Derek.
we have a motion on that vote?
I make a motion to approve the minutes as presented.
Second.
August.
Ask for it.
All right, we have a second. Just want to make sure that's reflected in the minutes.
All in favor? Aye, aye.
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 Presentation time. Is the computer for this over here? Yeah, I may steal that chair, not for you.
Go ahead, no, go ahead, take
Yeah.
that. Yep.
All right. Everyone hear me all right?
Yes.
We'll cross his name out.
So, as a part of the orientation process, I'm going to go through 2 PowerPoints tonight. I'll try to go through it as quickly as possible. If it's information you already know, say, hey Garrett, we already know what this is, we don't need to be reminded, I will move right along.
Did you do this, Ron? Did you do this?
Here we go. Yeah.
First portion of the presentation is going to cover sunshine law, public records law, voting conflicts. I know you all probably know very well what the sunshine law is. We're going to briefly go over that. Same thing with public records. We're mainly going to focus on some practical pointers for you guys to keep an eye on. And we will spend a little bit more time on voting conflicts because that is something that may arise. After that, we're going to talk about parliamentary procedure, right? How the board governs itself, making motions, making seconds, how it all works. What I want you guys to specifically kind of focus on in that process to make sure all of our meetings in the future are smooth. And finally, we'll close out with what I think is the most pertinent and important information, and that is quasi-judicial procedure, right? Everything this board does is when you guys have items come before you, they are all quasi-judicial in nature. So we'll talk about what that is, what to watch out for, and hopefully you guys enjoy the presentation. I will try to go through this as quickly as possible, but it might run up in 45 minutes. So what is the Sunshine Law? Provides public a right of access to our meetings, right? It applies to elected boards like our city council board. It also applies to this board as an appointed board, all right? The general rule that I want you guys to keep in mind is that all meetings in which official actions take place or transaction or discussed have to happen at an open and noticed public meeting, all right? So 2 requirements there, open and noticed. We'll talk about that very briefly. What's a meeting? Normal meeting where items are decided, right? Maybe a workshop where there's a particular project that's up for discussion, or informal discussions between board members. It could also be a telephone call or a text message, right? Emails, other written correspondence, even informally talking outside of the parking lot could be construed as a meeting.
We're getting a lot of interference.
3 basic requirements for meetings, right? They have to be opened to the public. There has to be reasonable notice of such meetings. And we have to take minutes, right? We have to take good minutes and make sure they're open to public inspection. That's why we ask for motions and seconds. That's why just a moment ago, in the approval of the minutes, right, I wanted to make sure we had a motion and a second on the record so that we could have that reflected in the minutes.
So whose responsibility is it for the minutes? Is that Corey?
Yes.
Okay.
That's correct. So we're not going to go through any hypotheticals tonight. So what is sunshine law really getting at, right? Sunshine law, if there's a communication between 2 or more board members of the same board, that is where you are going to run into issues, right? Those types of communications are prohibited under the sunshine law. Why is that? That is because meetings, the meeting requirement, every meeting between 2 or more members of the same board has to be made at an open and noticed public hearing, right, where the public can participate. If board members are having conversations amongst themselves about items that may foreseeably come before the board, right, that's where you're going to run into issues, okay? That's what the sunshine law tries to prohibit.
Can I?
Yeah.
I'm close to one of the alternates, and every time a project comes up, we'll go on site to look at it together. Is that a problem?
It may be, yeah. I would recommend that you do any of your work, right, your prep work for an agenda item alone or with someone who is not a member of the board. The reason why is, you guys may drive up to the site, not talk at all, review it independently, get in the same car and drive away. If there's a savvy opponent to whatever's taking place, that could be a basis to overturn a validly reached decision. So even the appearance of impropriety could raise a lawsuit that would delay an entitlement that someone would receive before the board. So we're going to want to keep those interactions out of our prep work. So you as a board are more than welcome to communicate with staff on items that come up from time to time. If there's a particular portion of the code or a particular issue that you come across in your packet and you were just thinking, I have no idea what the analysis is here, what is going on, you can absolutely feel free to reach out to staff to get those clarifications. I would advise that you not ask in that moment for a ton of detail or staff's opinion, right? That's all going to be laid out in your packets that you're going to receive. Those are going to be highly detailed. They'll either include a recommendation or they'll say we find that the applicant has satisfactorily met the criteria in the code, and they'll leave it up to you whether or not to grant or deny, right? So we'll talk about in a little bit why we maybe want to limit those conversations to just getting the information you need, right? But discussions between board members, prohibited. If a city, another elected official in the city comes to you and says, hey, I want to talk to you about this variance request that's coming up, that conversation is completely fine, right? They're not a member of this board. Just a little bit more about meetings. They have to be, by open to the public, they have to be in a location accessible to the public, right? We have a road that leads here, a big parking lot. We have lots of empty chairs here in the audience. Lots of space for the public to come out and participate in our meetings. We also put them, even though it's not legally required, we put them up on YouTube for folks to watch, which is very helpful. And we can't discriminate or restrict access to the public. There may be a few hot button issues coming before the board this year on some big projects, and there might be news cameras in the back, and that is completely fine so long as they are not being distracting while they're taking video or photographs. That is permissible under Florida law. The right to public input is not unlimited, right? We are allowed to adopt reasonable rules for when folks want to come and give public comment. Some of our items will have public comment, others won't. I believe we have a general public comment portion at the top of meetings. We're allowed to limit those comments to a reasonable time. I think generally we stick to the 3-minute rule here, which is perfectly fine. Most of these requirements, too, are more for larger boards like the city council. We make sure you all follow these rules, but the issues don't pop up as often with boards like yours. So we want to make sure that we follow the Sunshine Law because while there are non-criminal infractions that can result if you're found to have a Sunshine Law violation, knowing violations could include up to a year in jail. It's no joke, right? There's nothing worse, I'm told, it hasn't happened to me yet, than getting a call from a state investigator asking if you have time to sit down for an interview. So we always caution folks against having these communications with fellow board members. If you ever have a question about a conversation you were about to have is good or not, just give me a call, right? All of you will have my cell phone number by the end of the night, so you guys can give me a ring. I'll answer your call same day for sure, and we can make sure that any conversation you're going to have is going to be okay.
Do you represent the board or the city?
So our firm represents the city as the city attorney. While you all are deciding cases that come before you, right, applications for variances or whatever, I represent you all in helping you all formulate your decisions, right? I make sure the process is correct. I make sure that the board follow due process, right? We'll talk about that in a little bit. And I make sure that the ultimate decision that you all reach, I try really hard to make sure it's a valid decision, right? It's my job to make sure that your will happens. So I try to, massage out any issues during the meeting that might arise. If there's ever a lawsuit, last year, this board approved a variance for a dock here in Cocoa Beach. And there was a lawsuit that resulted from that. Our firm represents the city in that lawsuit to defend your decision, right? And we were successful on that lawsuit because everything worked out well at the board level. So that's what my job is here. Did I answer your question?
Yes.
So just one quick point on this. Any decision that is reached as a result of a Sunshine Law violation, void immediately, okay? Not voidable, doesn't take a court proceeding to render it void, but if there's evidence of a Sunshine Law violation, the decision is void ab initio, right? And that's what the legislature prescribed here because they want you guys to know, even if you try to pull one over on your fellow board members to work out how you're going to come down on a case before the case happens, you're still not going to be successful because whatever you voted on will be void. That was a very, very quick overview of Sunshine Law. I know you guys aren't going to talk to each other. You guys aren't going to call each other about your staff packets you received to figure out what the right thing to do is. I'll tell you that even if you have questions for me about how you feel about a particular item before the meeting, I'm usually here about 45 minutes before meetings when we have action items, so that you can pull me aside, you can pull me to the back of the room, and we can talk about any questions you have, right? Even those conversations have to happen separate from other board members. All right? Just think about it. I mean, if you're standing next to me and we're having a conversation about how you feel about a particular item, and there's another board member right there, that's a communication between two or more members of the same board outside of a noticed public meeting, right? We talked about how meetings can be informal discussions, text messages, phone calls, right? So that could be construed as a sunshine violation.
Under your example, if I ask you questions out there, is that privileged? Is that protected by privilege?
By privilege, do you mean attorney-client privilege?
Yeah, so if you're representing the board and I have a question, and I'm just curious.
Yeah, I mean, if you ask me a question, it'll stay between us. I'm not gonna go around and say, oh, John asked me this and that. I mean, there's no legal, privilege, right?
Okay.
Our client is the city council, those board members. We represent the city too as well, but in a sense, I represent the board when you guys are in session, right? Trying to ascertain whether you're gonna vote yes or no on the requests that come before you. That's my input. But if on a, Saturday afternoon, you go to a restaurant with someone else on the board and you wanna know how much you can really talk about, I represent you in that moment too, right? Because it's about your board duties. So feel free to call me, and we can chat about all that. Public records law. I saw one of you texting during this presentation. We're going to talk a little bit about text messages. In this meeting, I'm not gonna knock you for it.
I was actually writing myself notes.
Okay. We'll talk about notes as well. I'm going to pick on you for this.
He's the chairman.
We're going to talk about
Chairman
notes.
emeritus at this point.
So does everyone knows that they are an appointed member of a city board, right, a public board, and because of that, the Public Records Act applies to you, the same as it applies to everyone else who works for the city, including myself, all right? Florida Public Records Act, it provides a right of access to the records of state and local governments, right, as well as private entities like the Post Law Firm. It's also embedded in Florida's Constitution, Article 1, Section 24, and there are narrow exceptions that apply in the Constitution and in state law, but again, they are narrow, all right? So what is a public record? What can constitute a public record? As you see here, pretty much everything, right? All documents, papers, letters, maps, books, tapes, or other materials regardless of physical form, characteristics, or means of transmission. Made, and this is the key part I want you guys to focus on, all of that, right, made or received pursuant to law or ordinance, or in connection with the transaction of official business by any agency. Okay? This definition is quite inclusive, right? It's any document, paper, communication, regardless of whether it's in its final form, made or received pursuant to law or ordinance, or in connection with the transaction of any official business by the agency. Florida Supreme Court took that kind of beefy definition, it's pared it down quite a bit, made it a little easier to understand, right? All materials made or received by an agency in connection with official business which are used to perpetuate, communicate, or formalize knowledge. Right? You may say, Garrett, that's even more confusing than the first definition. You might be right, so we're going to go over it. What does that mean? So we're talking about all materials, regardless of whether they're in final form. Drafts of documents, public records. Right? The final version, public record. All right? All of these materials are open for public inspection, unless the legislature has exempted them from disclosure. I'm going to walk through a hypothetical here in a minute about texting during the meeting or passing notes during a meeting. That'll surprise you all and will hopefully put you in the right frame of mind for some of our more public items that are coming up later this year. There's no exception for, Garrett, this is really embarrassing. I really don't want to show this, Channel 9 News, what I sent, during the meeting. Can I just, delete the text? The answer is no. Or this email is really embarrassing where I'm bad-mouthing this applicant coming up to the board. Do you mind if we just keep it out of the production? No, it's a public record. All right?
I text my wife, I'll be 15 minutes late for dinner, is public records?
Well, I'll answer that question in a minute. I want to hold off on that because it's not, but we'll talk about it. Emails, right? Electronic records, of course, those are public records as well, made or received by public officers or employees. You all are public officers, okay? So this applies to you. They're subject to disclosure in the absence of an exemption.
Question.
Yes?
Do we have any obligations to retain emails received by us?
You guys are asking the best questions tonight compared to the planning. You guys are kicking the planning board's butt on questions. If you are in possession of a public record, you are the custodian of that record, okay? Now, presumably, I say presumably, if you get an email communication from staff or from myself, anyone else associated with the city, you can rest assured that the city is going to maintain that email to you, right? So I would recommend that you maybe create a folder where you save those emails. But the city is going to have a copy of that email in our records, and that is enough to preserve the record.
Okay, so we aren't required to reprove, if we were to be subpoenaed or had to provide discovery, and I did not retain those, I would have a reasonable argument. This came from a city official. I thought that the city gave me the requirement to be a custodian of those records if it comes from, so I'm not going to be emailing anyone else other than probably staff, so.
Yeah, well, that's a good
Keep it
point.
simple.
Just for the board's benefit, the way these requests work is you're not going to get a subpoena in the mail. It's not like a formal discovery request in litigation. There will be a public records request that comes into the city clerk. The clerk's job is he or she's going to reach out and ask everyone who might have those records, hey, here's the request. We're going to produce whatever they ask for. We're going to have the attorneys look over it maybe if there's any issues. And generally speaking, if you get an email from staff, those emails are going to be archived and saved, so you are good to go. What I would strongly recommend, whatever email address you've given the city to communicate with you, if it's a Gmail, just make a little folder in your Gmail, Cocoa Beach Board of Adjustment, and when you're done with an email chain, just drag it right into that folder. It's out of your inbox, you don't have to worry about it, but it's there.
Oh, we don't get a city email why wouldn't they give us a city email so we don't have to
They get a
have our
city email.
personal email be discoverable?
It's not discoverable. Your personal email is not discoverable.
Okay.
No one's going to log in.
Yeah.
It'll just be you might get an email from me saying, hey, we've gotten a request for all emails, between members of the Board of Adjustment. Do you have any? I'll just ask you. And if you don't, then that's fine.
Okay.
Awesome. If you do, say, hey, Garrett, here are all my emails. I'll let you decide whether any apply. That's fine too. No one's going to come looking in your email.
Because we pretty much cannot email each other anyway.
That's right. Yeah, about
If you created
about
Word
business.
product.
Yeah.
Right, correct.
Yeah. But if they just want, all your emails, regarding your official duties, then, the city will have those, but it'd be helpful if you all had a set as well, so we can make sure we're all good.
But do you have a list of things that we can do to make sure we don't inadvertently create? Because it sounds like if you're here, that shouldn't be that hard. So long as, under that definition, it should be reasonably easy not to have stuff other than when you're emailing back and forth with the city, which is already retained.
Exactly, yeah,
So the best way to avoid that is to just not create it.
exactly. That's
Okay, so
right.
do you have a list to help us make sure that we don't inadvertently create stuff that we would have to provide under the sunshine? I mean, the Board of Adjustment's pretty easy,
Yeah, and I have lots of little practical tips for you guys at the end of what we're going through here. Let's get through the rest
Okay.
of the public records portion. It's not as scary, I promise, as it appears to be.
Garrett, if I might,
Yeah,
what has worked for me is if you need to ask a question, phone call.
that's what that's what we're getting to.
Yeah, okay.
That's my big punchline at the end. Sorry about that.
The really only emails you're gonna get are either a notification of a meeting and details on a new.
Right, they're all gonna be one way, but they're not gonna be
That's it.
Excellent.
If you
Yeah.
all
amongst ourselves.
I'll just get to it now. If you all ever have a question for me or for staff, pick up the phone. Phone calls are not public records. Okay? We can talk about anything you want, the weather, what you shot the last time you played the Cocoa Beach course, and you can ask me anything about any item on the agenda. It's not a public record. You can tell me what you think about a project. It's not going to be archived in some, transcript somewhere with the city, all right?
Got it.
That's with staff as well.
Yep.
Cool. But if you do have a public record, if you text me a question about board business, that's a communication made that's used to communicate knowledge, formalize knowledge, right? That text message is a public record. That's why if you're going to communicate with the city, with me, with anyone else about anything involving Board of Adjustments, do it by email. It's super easy to keep all that together on email. Much harder when you're texting. There are penalties for folks who do not maintain records as they're supposed to. You guys are going to do a great job of that. I hope I've sufficiently scared you into not creating public records in the first place. But if you do, just make sure save them in a file. We don't have to talk about the penalties because you guys won't run into it, but there could be civil and there's criminal penalties that are assignable as well.
Ron, how long do you think you could survive inside?
Not long.
This, we're almost through the first slide deck, talking about voting conflicts. This may seem a little more abstract than what we just went through. If you ever, I'll start this off by saying, if it's confusing, I'm right there with you, all right? If there's ever a question about a voting conflict that you think you might have when you're reviewing your agenda items, the first thing you do is call me. Because it's a lot easier to work out whether or not you have a conflict, right, if we're not in a public setting. And we have to discuss everything in the open. Or it's 5 minutes before the meeting, and you have a very, very, very close case. And maybe it is a conflict. And maybe on this particular night, we only have 3 board members that are able to come. And maybe because you're conflicted out, the only item on the agenda that night can't go because we don't have a quorum anymore, right? So it's very important, practically and for your own sake, that if you think you have a conflict, even if it's a 10% chance, give me a call, all right? That's why I have this little note on the slide, right? So we're looking at section 112.3143 Florida statutes. If you want to do a little late night reading, I would ask that you go ahead and read this in Florida statutes. It's very confusing. So that is why if you have any questions, please give me a call. Who does who does voting conflict laws apply to? Again, you all are public officers. This applies to public officers, right? If you are an elected or in an appointed position, all of you are appointed to this board. This applies to you. So what is a voting conflict? What are we talking about here, right? Any measure which would inure to your special private gain or loss, or any measure which you know would inure to the special private gain or loss of a principal by whom you're retained, a parent organization or subsidiary of that corporate principal by whom you're retained, a relative, or a business associate, okay? Again, confusing, we're going to talk about it. Who's a principal, right? The first bullet point is pretty self-explanatory, right? If someone, let's say you and your spouse are coming in and you want a variance for your dock to be put in on your property. That's an obvious conflict, right? That would surely inure to your private gain or loss because you're getting some entitlement from the city, right? Putting a dock on your property is probably going to improve your property value substantially, right? And it's only going to really improve your property value. So it's a special gain, right? It's not a gain that's felt by other folks in the community, not even your neighbors, right? So that's self-explanatory. We're going to talk now about these 4 sub-bullet points, right, where you know it would inure to the special private gain or loss of those 4 classes of folks. Talk about the first one here. Who's a principal? An employer, right? If you're employed and your employer comes and has an application before the Board of Adjustments, call me. Any of your clients, if you're in a professional practice and any of your clients come before you with a request, call me. Same thing if it's a parent corporation or a subsidiary corporation, right? But it's really the same company as who you're employed by, call me. Who's a relative? Pretty short list here. Any of those folks have any items that come before the board, again, call me.
Question, go back real quick?
Yeah.
Okay, thank you.
Yeah, that note there for the much larger slide deck where we give to our city council that commissions that we represent the anti-nepotism and gift laws. It's pretty funny. The definition of relative explodes. It's comical. But we just put a little note in our slides to let people know that those definitions are all different. But for your purposes, for whether or not you have a voting conflict, those are the folks who would apply.
Not that this applies to me at all, but I don't see uncle, aunt, cousin as being defined as a relative.
So they are not relatives under voting conflict law.
Okay.
Yep, we're looking at father, mother, son, daughter, husband, wife, brother, sister, father-in-law, mother-in-law, son-in-law, or daughter-in-law. All right. A business associate, if you have a common commercial or entrepreneurial pursuit, right, that individual is going to be your business associate, or if there's a current ongoing business relationship with an individual or an individual who owns another business, right, that's going to be, I hope that, dings something in your head. I got to call Garrett, ask him if it's okay if I vote at the next meeting. Right, so we've identified the different classes of folks, right? Any measure that would benefit yourself, and then we talked about any measure which would benefit those 4 classes of people. We're now going to talk about what is special private gain or loss, right? Voting conflict law does not apply to all situations which might result in a gain or loss, right? The gain or loss has to be special. Interestingly, there are many, many, many different times where your companion board, the planning board, would have questions about a special private gain or loss. They deal with legislative items that impact the whole city, right? They help make recommendations to the city board members on rewriting different portions of the code, right? On changing future land use maps, on approving real big projects that might actually impact their property values. So this test is much harder with them. With you, it's a lot easier because the sorts of requests that people come in to this board with, there's a much lower chance of there being this special private gain or loss. All right, requires an economic benefit or harm. It's not just everyone's going to benefit because there's a new flashy hotel over here that we approved a variance for, right? It has to be a special economic benefit or harm to you or to those classes of folks that we discussed. So what do we look at? Well, how big's the class, right? You can't have a special harm or benefit if the class of people is the whole city of Cocoa Beach, right? What's the relative benefit or harm when compared to other members of the affected class, right? So what's the benefit to you versus your neighbor versus someone down the street perhaps? Okay, we'll look at some points like that. Is the gain or loss remote or speculative, right? If it's a 50-50 chance that there's a gain or loss, is that going to be enough? And then is the matter a preliminary matter or a procedural matter, right? Like approving the minutes. Talk about that as well. Right? So smaller the class, higher the chance of there being special gain, and vice versa. Pretty self-explanatory. Generally, if it's better than a 50% chance that there is going to be a gain or loss, that's when I'll give you a call back in 30 minutes when I have time to chat about it with the city attorneys, Wade or Becky Vos, right? Generally, where whether or not the gain or loss is probable, right, more than 50%, that is where we will recommend to you all that you abstain from voting for that particular item. Okay? And this analysis is highly individualized. We'll talk a lot about key little facts and points, and generally in the middle of our discussions we'll realize there's no conflict. Generally, there's no conflict, but it's always nice to check. Preliminary matters or procedural matters, right? Approval of the agenda, approving the item that is on the agenda, right? Hey, I approve, I vote to approve the order of the agenda, or I vote to approve the minutes of a prior meeting where I was conflicted on a particular item. You're not going to have to sit out for those votes, right? Because the matter's already occurred, right? There's already been a vote. You weren't a part of that vote, so everything there will be fine. It only applies to the actual item before you. So in the very unlikely event that you do have a voting conflict, what do? First thing you do is you call me. There should be a 0 here. Call Gary, right? Then after we have identified that you have a conflict, you're going to abstain from voting. On top of that, you're going to disclose orally before the vote on the item that you have a conflict. And additionally, you're going to file what's called a Form 8B within 15 days, and you're going to give it to the city. If there ever is a conflict, we will provide you with that form. It has to be made a portion of the record for the next meeting and a part of the minutes. That's why we have you fill it out within 15 days, so we can get it off to the appropriate agency of the state, and it can be a part of the minutes, right?
Do you recommend that we not discuss from the, even, so if we do, let's say I have a conflict, and we're talking, or they are talking, hypothetically, let's say I have the conflict, I disclose up here, do I then abstain from questions from the dais also, or?
So, I'll pick on you. So let's say you have a conflict. Let's say we have one item, or 2 items on the agenda. Let's say the item you have a conflict on is the second item. You would go through, we'd open the meeting, things would go through. We have a portion of our agenda where we disclose conflicts. At that point, that's the appropriate time for you to say, hey, on agenda item D2 of the action agenda, I have a conflict. I will not be a part of that vote or that discussion. So we would proceed, we'd go through with the first.
So that's my question is,
Yeah.
so do you not participate in the discussion, or is it, do you not participate in the vote? Because there it says you abstain from voting, okay, either.
Yeah, so there's a difference between folks who are elected and folks who are appointed, right? So appointed officers have to disclose conflict before you even participate in discussion on the matter.
Okay.
You are not involved at all, right? Whereas if the Brevard County Commissioners, if there was an item before them that they had a conflict on, they could call the item, they could have participation, they can say this is the best thing to happen to Brevard County since NASA coming here, and then right before the vote they go, and by the way, my brother owns the company.
Wow.
I can't stop it,
Okay.
right? But appointed boards in Florida have different rules. Planning boards, Board of Adjustments, right? You all have to disclose the conflict before the item's called. That is why we have, gone ahead and placed that disclosure to occur before we even get to anything on the agenda. There are some very slight exceptions. Is anyone here employed by a public agency? Nope, don't talk about it. We're not dealing with a 1 acre, 1 vote system here. If the measure affects your expenses or compensation as provided by law, you can vote. This is how commissions across the state of Florida can vote to raise their salaries for being council people or commissioners, right? Because usually their charter says they're entitled to some compensation. They can vote to affect it, right? You guys don't get paid. You guys volunteer your time, which is fantastic. So appreciate that. So that won't affect us either. Let's talk a little bit about Section 286. I want to start out by saying that you guys were appointed to the position you're in for a reason, right? You guys are thought to have good judgment, good reason. That's why you're on this board. So I highly recommend whenever you have an opportunity to vote on an item that you do it. However, in the very rare circumstance where you do not have a voting conflict, but where there appears to be a voting conflict, you are able to abstain from voting on that particular item. And that is only when abstention, again, is to assure a fair proceeding free from potential bias or prejudice. So let's say, back to the relative point that was made earlier, your uncle's not a part of that definition of relative under Chapter 112, right? Let's say your uncle came up asking for a variance, special exception. You're not in conflict. There's no conflict. However, it may be good for you to abstain from voting in that scenario, right? We'll talk about that. There are some times when folks use this provision to get out of tough votes. And again, we always advise people, you are here to take the tough vote. So we always recommend, unless there is clearly some, perception of bias or prejudice, you all ought to vote. Okay?
Question.
Yes.
Does an abstention automatically, effectively become a no vote? In other words, if four items and 4 votes are needed, and you have 1 abstention, you only get 3 positive votes, in that case, is the abstention effectively a no vote?
So if you abstain from voting, you remove yourself from the whole proceeding. It's not counted as a no vote. If there were 4 board members and you have to abstain from voting, you would disclose that at the top of the meeting, just like we discussed if you had a normal voting conflict. Hey, I have I don't have an actual conflict. I have what appears to be a conflict. And in order for this item to be, decided without the perception of influence or bias, I'm going to remove myself. There are now 3 votes, right? So it's not like there's already a no vote. You're just out of the equation. So that was the quickest Sunshine Law public records and voting conflict talk I've ever given. That's a lot of material. This board really doesn't have the opportunity to talk to each other outside of board meetings, I hope. So Sunshine Law should never be an issue. Public records, I want you to remember, if you create a public record, if you send a text or communication about board business, or if you receive anything about board business, is a public record. You ought to hold on to it, right? Emails, we're going to create a folder. We're not going to send text messages. If we have any really tough questions to ask, staff or myself, we're going to pick up the phone, right? And all of you will have my number. That's how we're going to resolve that. I want to touch very briefly on private notes, right? Mr. Hayes, you were taking some private notes there.
Absolutely.
Presumably about the proceeding. Or about what
I wrote some too.
I think it's just what we wanted for lunch tomorrow.
So private private notes are generally not going to be public records, even if they're made in connection with board business. You get your your big thick packet from staff that I hope all of you read thoroughly before each meeting, and you jot down a couple notes. You circle a section with a big question mark, or you say, "What the heck is this?" with an arrow. Those types of notes that are just used to jog your memory, right? You're not using it to formalize or perpetuate or to communicate knowledge. Those notes are not public records. But the second you write something down on a piece of paper, show the individual next to you what you're writing.
That's not good.
That is now, right? That's a communication. You're writing and you're communicating knowledge, right? So the second you show your private notes to folks, it becomes a public record.
So what are the laws and rules, and how does it apply if an applicant contacts one of us directly, and there's now an email between an applicant and myself, that would be a public record?
That is called an ex parte communication. I'm so glad you brought that up. We are going to get into that in about 20 minutes. We're not going to have those, so I'm very glad you brought that up. That would also be a public record, right? That's a communication received in connection with official board business. And presumably, the applicant is using the email to communicate with you, right? So that's absolutely a public record. You're going to want to save it, and then we'll learn in a little bit why we're going to want to disclose that communication before an item comes up before the board. Very good point. Parliamentary procedures. I know I have two new board members. I will go through this very quickly for you all. I know my other board members know about parliamentary procedure already, and then we're going to talk about quasi-judicial hearings, due process issues, things to watch out for, and then as we just brought up, we're going to talk about ex parte communications very briefly. So the board uses a procedure to move through items, right, to approve items, to vote items down, to approve minutes, to adjourn, right? We do that to maintain order and to promote efficient proceedings. Every meeting is going to have an agenda. We're going to follow the agenda in how we go about getting to items on the agenda. If there's ever a want or a need for it, usually comes from staff. They may say, hey, you know, the applicant for this one item is pressed for time, or they have a flight to catch. You know, we're going to switch the items on the agenda. You can always have a motion to vote at the top of the meeting to amend the agenda, right? To switch items in order. Things like that happen quite frequently, but generally, we're going to follow the order of the agenda. Generally, we're only going to discuss topics that are on the agenda. There will be a portion of the meeting at the end where if you all want to discuss kind of general matters, you know, things you want from staff, things you want from me, you know, more than happy to discuss it at that time. But generally, when we're on one topic, when we're, you know, hearing a request from an applicant for a variance, we're not going to talk about the request for a special exception we just had, right? We're going to try to stick to what is on the agenda before us. We're not going to want to talk over each other. That's for two reasons. Number one, we have to keep great minutes as provided by law, right? We have to make sure that we have excellent minutes for members of the public to review. And second, there may be items that come before you that are incredibly contentious, that are so contentious that applicants or maybe members of the public who have interests in a particular item, who have standing, maybe perhaps to sue in the future, they might bring a court reporter to the meetings. And he or she will sit very close to where folks were speaking and will take down a verbatim record of the proceedings, right? And in those instances, we want to make sure we have a crystal clear record. It would be horrible for good evidence to be given or discussed, or maybe it's the reason for the whole vote is discussed, but folks are talking over each other. Court reporter can't get it down. There's an appeal filed, and now the record's so messed up, we have to have a new proceeding, right? Yes.
So this happens at a lot of commission meetings where the public comment section seems to get out of control and ends up being a dialogue between the commission and the person commenting. And I know that that's a violation of the rules. Would that be a sufficient violation of the rules for someone to challenge the entire meeting?
So generally, for most of the items that come before you all, there is not a dedicated public comment portion. And that's, sometimes there will be, but very often there won't be. We'll talk about why. We probably just want to let those individuals talk in a minute when we go through quasi-judicial procedure. But what I recommend is if there is public comment during an item, during the meeting, we just hear them for the 3 minutes that they're entitled to, and we, you know, thank them. If we do want to, you know, go back and forth, that's fine. It's not going to invalidate anything. But, we have a rule, 3 minutes per individual. Generally, we advise folks, stick to the rules so that way, someone who maybe gets cut short, will say, oh, well, they let someone else go long every single time they went long. They never let me go long, right? They're discriminating against me. They're restricting my right to, be heard at public meetings. So to avoid issues like that, we try to stick to the rules. Final point on speaking, we have a chair, right? If there's a particular time during an item where it's not up for the board's discussion, raise your hand, hey chair, can I ask a question? Hey chair, can I speak? Chair, yep, go ahead, right? That way we kind of keep discussion orderly. To do things, we need to make motions, right? And for motions to survive, there needs to be a second. And once there's a second, we can call a vote. If there's a motion and no second, the motion dies. Okay. That is the quick rule. That is how you all take action, right? Generally what will happen is staff will give a great presentation on an item. The applicant will come up, give a presentation, make themselves available for questions. And then after that, the chair will say, board, discussion's up here. Board, it's back up to us. That's your opportunity to discuss the items, to ask questions of staff or the applicant. And at that time, if everyone's satisfied with what they've heard, there can be a motion. When there's a motion and a second, generally there's not much discussion after that, because you're going to want to discuss matters before the motion's made. If anyone's ever confused about what a motion is, raise your hand and say, I don't understand the motion, or can we clarify the motion? Oftentimes it'll be myself who will pipe up and say, I think you meant something else, right? And then we'll go over it, we'll talk about the motion, and then you can always amend your motion, right? Then we'll have a vote. Usually votes will be just voice votes, right? Chair will say all in favor, say aye. If you want to affirm, you say aye. All opposed, like sign, right? Aye at that point if you do not wish to vote for the item, and our board clerk will essentially call the vote at that point, right? Unanimous, 4-1, 3-2, just for the record, right?
May I ask, what is I've heard of yay and nay, I've never heard of the like sign. What is?
It'll be, it can be yay or nay. Usually like sign is you just say the same thing, but for the opposite, reason. Right, we can make amendments to motions. Maybe you have a vague motion and you don't really know why you're making it, but you want to affirm something, right? We can work that out after you make the motion. Once the motion's second, right, and then we need an amendment, there needs to be a second to the amended motion, so we have a chain for the minutes. Let's say there's a motion made to approve variance 24-001 to allow a dock at, some particular property. And there's no second. Or maybe there's a second and there's a vote and the motion fails, 3-2. What happens next? Is that it? Does the applicant go home? What happens next? Anyone want to take a guess?
It's over.
Motion fails, it's over.
Motion fails, but
The vote fails.
what's going to need to happen is there's going to need to be a motion to deny the variance, right? We need think of it like this, we need an affirmative vote either way, right? An affirmative vote to approve, affirmative vote to deny, right? So if the motion fails, right? 3-2, motion fails. All right, board, we need a new motion.
Okay, so it requires a 4-1. I'm told a lot of ours require 4-1. So if it's 3-2, so it doesn't meet the 4-1 threshold, then one of the nay votes has got to make a motion to deny, and that motion, how is that motion going to get seconded?
So the board member has to change, whoever voted for it will have to, again, change their vote negative after they voted positive.
Well, no, I guess I guess if it's a 3-2, it might be different, but no, on situations where we need a 4-1 vote, well, that's interesting. I didn't realize some of our votes have to be 4-1.
All of them are.
All of them are?
Here, all variances, special exceptions are 4-1.
Yeah.
For approval or denial.
Generally, what you need is an affirmative vote, either way, right? A vote to approve.
Do you all, I
Votes
haven't
denied.
been in a meeting with you, but do you all still write our motions for us?
Yes.
But if there's only one voting, well, if there are only two voting against it, then I guess you get a motion a second, but the motion to deny would fail.
We normally would say, I'm sorry, the motion failed.
Yeah, generally you need a motion. I'll look into it on for this particular board. Generally, you need an affirmative motion either way.
Yeah, I hate negative motions. They get very
If you gotta do them, you
confusing.
gotta do them.
I hear
If
it.
you gotta do them, you gotta do them.
No, you don't have to.
The last point on parliamentary procedure kind of gets into our next item. But when you're discussing whether to vote for or against a particular item, it is always best practice to discuss reasons why you're reaching that conclusion, right? Hey, I don't think they've met, one of the criteria for a variance. Discuss why. I didn't hear any evidence supporting this particular criteria. That's why I'm going to make a motion to deny the request, right? We want to make sure that kind of information is on the record so that when we turn around and prepare the order, right, based on whatever the motion is, that information can be reflected in the order, right? It's required by law that the reason for, the up or down is in the order, and the only way we can do that is if that information is communicated by you all during the meeting.
Is that's drafted in the motion? Like, do I have to justify my vote whenever I vote? Or do you do that when you draft the final motion, which we read and then vote on?
Yeah, so the way it works is that you all, let's say it's a unanimous vote to deny, right? And you guys deny, and let's say there's no reason on the record for the denial. You guys just heard the testimony, and that's it, and there was no discussion. I make a motion, we deny the variance request. Second, all in favor say aye, unanimous vote. At that point, I don't know what to put in the order, or staff doesn't know what to put in the order. And it's not like you guys turn around and, at the next meeting, approve orders that were decided the month before, right? The decision happens right there while the applicant's here, right? So, I moved to deny the request because they failed to meet, one of the 6 criteria we have. They failed to meet this criteria. I didn't hear any evidence on that, so.
All the criteria are spelled out on each of the applications, positive and negative, so.
And when you guys make a motion, the only thing that happens after that is the chair will sign off on the motion, and a certified copy will end up with staff, and that's it. The order doesn't come back to you all for a vote, right? Yes.
So in that 3-2 scenario, and the two votes effectively deny the motion, at what point do those two people voting to deny the motion, at what point do they have to disclose their reasons for denying the motion?
Well, that's why I was saying generally you need an affirmative vote either way, yes or no, so that way you can put a reason in the order denying the motion or approving the motion.
It'll turn out to be a pretty spirited discussion if it's that close.
Yeah.
So everybody will have something.
Yeah. But I think some of your questions will be answered here at the very end of the presentation. I promise I'm almost done. Quasi-judicial hearings, right? You guys know what judicial hearings are. You've seen Law and Order, right? You've seen all the stuff on the news recently, all the different formal judgments that are going on, right? You all, just like a normal judge, you're an adjudicative body. All right. What do I mean by that? Under Florida law, there are times where boards, particularly this board, every time you guys act, you're in a quasi-judicial manner, right? That's when you might act as a judge. Your planning board counterparts, they have these things called legislative items. It's where they get to make policy. right? They get to recommend changes, they get to approve changes to the comprehensive plan, right? Those are legislative, right? Because they're creating new standards, they're creating new rules, new map amendments, right? Whereas you all take existing rules. What's the standard for a variance? What's the standard for a special exception for this particular zoning, right? And then you're applying facts that the applicants bring you, the staff brings you, and you're applying those facts that you hear here to that existing law. And then you say yay or nay, right? So you all are kind of acting as a judge. There are no formal rules that apply to this body when you guys do your thing, right? There are some rules though. Not as strict as a real judicial action, right? Like in a circuit court down the street. But there are going to be some fundamental things we're going to want to follow, and we're going to talk about those right now. Do we know what these are? We have to afford two key things for every hearing, for every application that comes to us. The first is notice of hearing. We have to give adequate notice of the hearing. Someone can't come into city staff and say, hey, I'd like a variance for, this, for this aspect of my property. Oh yeah, all, friendly. Yeah, we'll work it up and then we'll let you know when you're going before the board. And then they never get notice in the mail. They never receive formal notice. Any other interested parties don't receive notice of the action who may be entitled to it. And we have a proceeding. They don't show up. We deny the application. Oh, so sorry, your application was denied. Right? We can't do that. We have to give adequate notice of the proceeding. Staff takes care of all that on the front. So that's not necessarily anything you all need to worry about. What you guys need to focus on is the second component, right? We have to give applicants an opportunity to be heard before the board, right? What does that mean? They have to be able to present evidence, cross-examine witnesses, and be informed, and this is a little poetic, but be informed of all the facts upon which the board acts. We'll talk about what that means and why getting an email from an applicant might not be okay, right, under this dynamic. Right. So we're talking about evidence here, right? All the facts, staff, great packet that they deliver to you all. Maybe the applicant has some materials that you all will get. There will be there may be a slide deck they present as a part of their presentation to you all. They may have engineers or architects or experts or surveyors or engineers come to the meeting and give their bona fides to you. I've been an engineer for 30 years in down in Melbourne, and here's my expertise, right? Folks are going to put on evidence. They're going to try to get you all to buy their side. So what kind of evidence do we need to base our decisions on? The law says we have to make our decisions based on relevant, competent, substantial evidence. All right, I'll read you the definition, then we'll talk a little bit about what we're looking for, right? Such evidence as will establish a substantial basis of fact from which a fact at issue can be reasonably inferred, and the evidence has to be sufficiently relevant and material, and that a reasonable mind would accept it as adequate to support the conclusion reached. Right? Only fact-based testimony or evidence is going to be considered by you all. So if any evidence is irrelevant, right? Maybe, we're talking, I keep picking on the subject, but a variance for a dock that might not be allowed. And someone says, well, my neighbor down in Satellite Beach had a dock like this go in, and they just hate it. So I'm going to deny this request because, that experience with my neighbor. That is not relevant, competent, substantial evidence to base your decision. It's not relevant. It's not about the issue before you, right? And even relevant evidence sometimes is not competent or substantial. It's not reaching the level that you would need to infer a reasonable fact finder would say, yeah, I agree with the engineer that, that piling would be 5 feet away from the other property line because they've showed me the survey, they've given me their testimony, that all checks out, right? if some member of the public or some other interested party comes up and says, well, you know, I have no experience in surveys or maps, but I can tell you that's not 5 feet, it's relevant evidence, it's about the matter at hand, but it's not going to be competent substantial, right? And we'll talk about why that is in a second. The black letter of it that I want you guys to burn into your brains, this question: is the board's decision supported by relevant, fact-based testimony or documentary evidence concerning the request before the board? Testimony, documentary evidence, is it relevant? I can use it, right? So maps, diagrams, reports, testimony from witnesses, from our staff. Our staff, professional staff, they are recognized as experts by Florida courts. So you can trust what they're saying. All right? Hearsay's fine too. So if someone says, oh, you know, my so-and-so heard this or that, it's not necessarily going to be excluded, right? There's no objection, you know, that's hearsay, board, it sustained my objection. It doesn't work like that. We can use hearsay generally with the kinds of items that are coming before you all. It's not going to come down to that. So, when members of the public or folks who are not considered experts, right? Joe Schmo off the street who comes in and talk about, how some survey that was submitted was done incorrectly. When the city's, folks and the surveyor for the applicant come in and tell you why it is correct and provide you with the survey, right? The opinion of a layperson, it's not going to get to the level of competent substantial evidence. Generally, that is the rule. There are some exceptions. These will almost never come up in your meetings where a member of the public will put on competent substantial evidence where they are not some sort of expert. If testimony's on a subjective matter, right, things that don't require expertise, it could be competent substantial evidence, but generally the weight of the evidence is going to support something else. Your decisions are not supposed to be popularity contests. It's not about how many folks show up to the meeting. It's not about how many emails, staff gets. The decision is based on what you all hear during the meeting. Okay, we'll talk about why that's important. What you come to learn reviewing your packet, the staff gives you and whatnot. And if you go to visit the site, you look at it with your own eyes. You can utilize that information, but we want to keep it based on the evidence that's before the board, right? What that's going to take, what that's going to come down to, right? When staff's done with their presentation, when the applicant is finished with their presentation, you all are going to get to assign weight to the evidence, right? You can ask additional questions too. Hey, can we have that survey pulled up again? Hey, can I have that photo pulled up again? Hey, applicant, I want to talk to your engineer again real quick. I have one unresolved item I need to ask about, right? That is completely fine. In quasi-judicial decisions, you just need some competent substantial evidence to support the decision. You don't need 51% of the evidence to support the decision, right? You don't need 95%. It doesn't need to be totally conclusive. It just needs to be some evidence there to support the decision. Even if the majority of the evidence points the other way, as long as there is some competent and substantial evidence, a little kernel out there for you to grab onto, you can go ahead and make a motion, and that motion will be valid, right? It'll be a legal motion. Or you get a legal order out of the motion, I should say. Last part of the presentation tonight. You guys are almost through hearing me have to talk. What are ex parte communications? They are communications between a decision maker, that's you all, and another party without the presence or permission of all other parties to the proceeding, okay?
So if an applicant calls you, maybe it's a developer, maybe it's a homeowner that lives down the street from you, you know, they knock on your door. Hey, John, I need to talk to you about my variance request coming up. You politely tell them, sorry, can't talk to you about that. Close the door, right? Because that would be a communication between the decision maker, yourself, and another party to the proceeding, the applicant, right? That is an ex parte communication. Unless, of course, you have the permission from the city to talk to that individual. But generally, that's not going to do it either, because sometimes there are other folks who are interested parties to the items that come before. The important thing to know about these sorts of communications is that the law says they are presumptively prejudicial, right? Presumed to be prejudiced at that point. And that could be it happens all the time, a basis to overturn an otherwise valid decision made by the board. So what happens if you happen to run into the developer and they talk to you a little bit about their special exception they're coming in for? Your neighbor, man, they just get your ear down at 4th Street. Oh, I gotta talk to you about this dock I wanna put in. And you hear just enough for it to be an issue. What do? Right? We disclose them before the board meeting. Before the item comes up, I'll ask, does anyone have any ex parte communications they'd like to disclose? Most folks, even though it's not an ex parte communication, most folks will say, I went to the site, I saw the site. That's it. Perfectly fine. Some people will say, yeah, I went to the site, the applicant had a chit chat with me, she told me about her business, and we went our separate ways. Right? We just need to explain a little bit of detail about the communication if there ever is one. So what does that look like? We have to identify the person or the group, entity that we talked with. I talked to the business owner when I went on the site visit, right? A quick summary of the subject. We talked about what her business is, and she told me that she's coming into the meeting tonight, right? That's all we talked about. We have to make sure that this disclosure again happens before the proceeding. You can't, there can't be a motion, a second, and oh, by the way, I had a 3-hour steak dinner with the applicant where she described to me why she really needs this variance approval.
And she
right?
paid.
Have to do it before the meeting, or before the item gets called. And then that disclosure is going to become a part of the record, right? If someone's here with a court reporter, it'll be reflected in the minutes, right? Once we do that, we are good. But we're not going to have them because we're going to avoid them, just like we're going to avoid communications between board members about board business. We went through a lot. You all are now experts in local government law as it relates to you. If you ever have any questions before you all leave, I'll give you my cell number so we can.
Oh, can you do that right now?
I'd love to give it over the internet, but unfortunately.
Oh, you can't do that? No.
But that's still a private part of it. But
Okay.
yeah, we'll go over my phone number, and if you guys ever have any questions, you just want to talk to me about local government stuff, you hear about a law that comes up, whatever you want to talk about, I'm more than happy to take.
I'll
the
get
call.
his number from you if we need it.
Our firm is on a flat rate fee with the city, which means if you call me one time this year or 100 times this year, the city pays the same amount. I'm always so happy to talk to folks who are on boards I represent. I find it helps a lot. If you ever think you have anything that you need to chat with me about before a meeting, please call me before the meeting so that we can hammer out an answer out of the public eye. All right?
Good.
Thanks, guys.
Thank you.
Yeah.
Thank you.
Some of you new guys, you gotta fill out that Form 1, you know what that is? Your Form 1, have you done that yet?
Form 1 being what?
Your financial status.
I already
sort
did
of- Yeah. We don't have to do the Form 6, thank God.
All right, so the next thing on the agenda is the introduction to the new staff. And I'll let Randy
I
speak.
was waiting on the chairman to invite me up.
That's some new staff.
Meet the new boss.
I would like to say, I'm a new staff member, Randy Stevenson, Director of Development Services, back for a period of time. So glad to be with you. I would like to say too, and extend staff's invitation. If you have any questions about something coming up on the agenda, call us, telephone call. Happy to talk to you about it. I'd rather you ask me in my office or one of the staff members in their office rather than this setting. It always works out better that way. Your primary contact is going to be Corey Hall on our staff, doing a great job, and he's going to be your primary point of contact. You can also call myself. Devin Talley is primarily working with our planning board, but she's also there. We emphasize teamwork here, so we're going to be doing this type of thing. We're going to be going back and forth and working together on this. And our principal planner back here, Lauren Wiltsey, I got it right. Didn't know if y'all had met them. They're fairly new too, not as new as me, but they're fairly new. So I wanted you to meet staff tonight and go over any of that. That having been said, I would delay any questions you might have on anything, any projects upcoming until after Corey gets a chance to go over with you the year-end report and the financial disclosures. Any questions of me at this point?
Thank you, Randy.
Thank you. You're up, sir.
So in your packet, you've got a year-end report, and this encapsulates everything that happened last year for your review. And we'll have to have it signed, approved, so if somebody wants to make the motion, I guess.
Motion to approve the year-end report.
Second.
All in favor?
Aye.
Okay, 4-0 vote, very good. And then we also have in your packet the number of completed permits for the financials. And basically we had 4,575 permits that were actually completed. Revenue generated from that is right around 1.2 million. So a lot of work got done.
Can I ask a question?
Sure.
It's been discussed for about the last 15, 18 months, all the short-term rentals, that we have like 1,187 or close to 1,200, and we only had 189 registered. So there was going to be a software company or somebody hired to start registering the gap. Has that happened?
That has happened. We have this company called Rentalscape that we are using, and they basically go out to all the different sites and pull in the information, and they're providing us with who's licensed and who isn't. That's helping us fix that gap.
So is there revenue being generated through them now?
Oh, yeah, I'm sure. And it'll be continuing. But I don't have the numbers.
It still says only
for that.
189, so I would have expected it to be a lot more than that. I mean,
September?
Well, the 189 is for the application, but when you go to the
BTR for vacation rental.
Oh, sorry.
it's up to 600 now?
Yeah, they're broken up.
All right, so there's a lot of progress then.
Yes.
Thank you.
Yeah. Thanks, Devin.
What
I
does-
guess I should take a look when I ask the question. Any other questions?
What does the city charge citizens to have a garage sale?
Nothing. All it does, they file a permit and it basically gets them on the city calendar, which is helpful for the applicant as well. Yeah, in that too. And also for the new folks, I attached a copy of the rules and procedures for the Board of Adjustment. That wasn't tied on this. This was kind of a last-minute thought.
Do we have any pending projects or people coming up for new projects?
Yeah, we have a couple coming up.
Okay.
I think in April, we'll probably see our first one.
Okay.
And I was checking my email. Michael did text me or email me and said he wouldn't be here, just my bad,
Okay.
right? Just so everybody knows. All right. Anything else? Any other questions? Well, welcome to the board, you guys. And thank you for your time.
You have to adjourn
Anybody want any member reports, say anything?
or? No.
No.
A motion to adjourn. Thank you.